1630, as the flagship Arbella, carrying the Puritan colonists, prepared to land in Salem, Massachusetts, their leader, John Winthrop, gathered them together on the deck of the ship and addressed them. For we must consider that we shall be as a city upon a hill. The eyes of all people are upon us, so that if we deal falsely in this work we have undertaken to build a new society, we shall be made a story and a byword throughout the world. We shall shame many of God's worthy servants and cause their prayers to be turned into curses upon us. The Puritans borrowed the phrase city upon a hill from the Sermon on the Mount in the Gospel of Matthew. You are the light of the world. A city set on a hill cannot be hidden. The term was embraced by President-elect John F. Kennedy in a speech delivered in 1961. I have been guided by the standard John Winthrop set before his shipmates 331 years ago. Today, the eyes of all people are truly upon us, and our government must be as a city upon a hill. For we are setting out upon a voyage, no less hazardous than that undertaken by the Puritans of governing the Massachusetts Bay Colony, beset as it was then by terror without and disorder within. For of those to whom much is given, much is required. When the eyes of the world fixed their glance on Little Rock, Arkansas in 1927, they saw 20,000 people gathered for the dedication of Little Rock Central High School. Hailed as the largest, most beautiful, and expensive high school in the United States, it opened its doors to white children only. 30 years later, in 1957, 9 African-American high school students faced an angry mob of 1,000 white Americans protesting integration. Violence escalated, and the children were removed from the school. The next day, President Dwight D. Eisenhower ordered the 1,200-man 101st Airborne Battle Group from Kentucky to escort the students into the school. The same order federalized the Arkansas National Guard, removing them from the control of the anti-integration governor, Orville Faubus. That event, watched by the nation and the world, was the first key test of the implementation of the U.S. Supreme Court's historic Brown versus Board of Education decision of 1954 that called for integration of schools. The Central High School case shaped the image of the state in the eyes of the world.
Some of the white kids there at Central, in fact, there's pictures of them yelling and shouting at the black children. You know, it really affected our economy and everything else. The corporations that move people down here, the first thing, of course, to look at is the school system for their children. And they see upheaval and problems in school, and it's taken a long time for us to erase. I don't think we erased the image yet, but it's blemished and it's fading.
Those negative perceptions would set the stage for 2 legal careers that attempted to challenge that image and set things right. Jack Holt Jr. and Philip Kaplan, young lawyers from vastly different social and political backgrounds, both received phone calls from U.S. Federal Court Judge J. Smith Henley, Christmas of 1969, appointing them to represent prisoners in the case of Holt versus Sarver.
I got a call from Judge J. Smith Henley, who was the judge who had been the presiding judge in 2 prior cases involving the Arkansas penitentiary system.
I had worked in the prosecuting attorney's office and attorney general's office involving criminal justice system in the state.
And he wanted Jack Holt because Jack had an extensive background. He had been an assistant attorney general, had a significant criminal practice at the time, and he wanted somebody who was more realistic instead of idealistic, and he thought that the 2 of us would make some good combination.
And likewise, Phil Kaplan was more versed in federal law, particularly in civil rights, and had a great expertise in that. And he said, we're getting so many writs, I feel like that maybe this is some sort of class action matter and civil rights, etc. And I said, and he asked me had I ever worked in that arena, and I said, no, I'm not. I'm looking at another lawyer to join in with you. And I said, okay. And he said, do you know Philip Kaplan? I said, is he that lawyer that's got a beard and everything? Conversely, he said, Philip Kaplan's worked in civil rights, and if I pointed just Phil, they say, well, you know, what do you expect? You got this civil libertarian there. He's going to raise havoc with everything down there. So what he said, and he said, I'd like to really perfect a marriage between the two.
I was among the very first. I guess I was just rebellious. I still am kind of rebellious about a lot of things. I did grow myself beard. The one lawyer in a school case wrote a letter to a judge in the case complaining about, I still have that letter, it's amazing, complaining about this communist. It came out communist in the letter, but it was probably communist when he said it, with his hirsute appearance. And why do we let these left-wing communists interfere with our public schools? His client was running a segregated school system at the time. What really is amazing is that here I come from this quite a different background than Jack in terms of our practices.
Yeah.
But there was never, I don't remember we ever had a word of disagreement about what to do or how to do it.
No,
Never.
never.
No.
Yeah. He got excited a couple of times.
The prisoners' rights era in the United States began with the case of Holt versus Sarver. This important period in the history of prisons must be understood in the context of a fundamental democratization that has transformed American society. The prisoners' rights era was a natural outgrowth of the social movements of the 1960s that recognized the legitimacy of grievances by various groups of people in our pluralist society. While the phrase prisoners' rights era might give the impression that prisoners won many victories in this period, it is not in fact the case. But the significant court battles that ensued and the rights that were won coalesced around Holt versus Sarver. The plaintiff, prisoners at Cummins and Tucker prisons, brought their case under Section 1983 of the U.S. Civil Rights Code of 1871. And that section of the code was promulgated after the Civil War to protect the rights of newly freed slaves from lawless activities of state officials. In 1967, Arkansas inaugurated Governor Winthrop Rockefeller to succeed six-term Governor Orville Faubus of Central High School fame. Rockefeller released a report on the state prison system. The report detailed horrific conditions at the two state penal farms. Governor Rockefeller brought in penologist Thomas Merton as Commissioner of Corrections to reform the prison system. In 1968, a widely publicized scandal broke at the prison after the skeletal remains of 3 inmates surfaced on the farm. The film Brubaker depicts life on the prison farm and the scandal through the eyes of a dynamic young reform warden closely modeled on Thomas Merton. Robert Redford portrays the fictionalized warden Henry Brubaker. The film was released in 1980 to wide acclaim and earned an Oscar nomination. In early February 1968, Merton ordered excavations on the grounds of the Cummins prison farm. 3 bodies were uncovered before the excavation was halted by the governor, although 15 to 25 depressions in the field were clearly visible, and Merton's inmate informant told him that as many as 200 bodies had been buried there. Merton was fired 2 months after the bodies were exhumed and the excavations were halted. Merton was told he had 24 hours to get out of the state or be arrested for grave robbing, a charge that carried a 21-year sentence under Arkansas law at the time. Merton's career as a correctional administrator was essentially over. In Holt versus Sarver, Robert Sarver, in sworn testimony, confirmed that the racially segregated facilities were in deplorable condition. According to the court's ruling, the prolonged confinement of numbers of men in the same cell under the described conditions was hazardous to health and offended modern sensibilities, and, in the court's estimation, amounted to cruel and unusual punishment. Federal Judge J. Smith Henley found that the state was unable to protect the inmates from harm and possible death. In addition, he found that racial discrimination was being practiced at the prisons. He noted that unlike other cases that challenged certain practices and abuses as they affected individual Arkansas convicts, this case constituted an attack on the system itself, the first time that an entire penitentiary system was challenged in any court. According to Judge Henley, a particular convict might challenge his beating with the penitentiary strap, being electrically shocked by the Tucker telephone, or being compelled to stand for long periods on the teeter board. But regardless of how conditions affect an individual inmate, the court found that confinement within a given institution can itself be so bad that it amounts to cruel and unusual punishment. It's one thing for a state to send a man to the penitentiary as punishment for crime. It's another thing for the state to delegate the governance of him to other convicts and to do nothing meaningful for his safety, well-being, and rehabilitation. It's one thing for the state not to pay a convict for his labor. It's something else to subject him to a situation in which he has to sell his blood to obtain money to pay for his own safety, or for adequate food, or for access to needed medical attention. However constitutionally tolerable the Arkansas system may have been in former years, it simply will not do today as the 20th century goes into its 8th decade.
There's a line in the sand for him, and he found that Arkansas had gone over it. It stepped across it from time to time, and I don't believe there was any notion of a moving line for him.
The Holt Court declared, for the ordinary convict, a sentence to the Arkansas Penitentiary today amounts to a banishment from civilized society to a dark and evil world, completely alien to the free world, a world that is administered by criminals under unwritten rules and customs completely foreign to free world culture. The obligation to eliminate existing unconstitutionalities does not depend upon what the legislature may do or upon what the governor may do. If Arkansas is going to operate a penitentiary system, it's going to have to be a system that is countenanced by the Constitution of the United States. In strong language, Arkansas prison officials were ordered by Henley to promptly eliminate the unconstitutional conditions that caused the court to condemn the system. The lives, safety, and health of human beings, to say nothing of their dignity, are at stake. The handwriting is on the wall, and it ought not to require a Daniel to read it. Unless conditions at the penitentiary farms are brought up to a level of constitutional tolerability, the farms can no longer be used for the confinement of convicts. The litigation did not end there. The state appealed Judge Henley's decision to the 8th Circuit Court of Appeals. Losing there, they appealed to the U.S. Supreme Court. The 23rd of June, 1978, the two young attorneys made their way to the Supreme Court of the U.S. Philip Kaplan, chief lawyer representing the Arkansas prisoners, addressed the Supreme Court on behalf of the legal team that included future Chief Justice of the Arkansas Supreme Court, Jack Holt, Jr.
Mr. Chief Justice, and may it please the Court, from the beginning of my participation in this case in December of 1969 until today, there have been 3 published district court opinions, 5 additional unpublished interim memoranda and orders of the district court, and 3 opinions in the Court of Appeals regarding the Arkansas Department of Corrections, and the administration of the Arkansas prison system. All of the findings of unconstitutionality of the Arkansas prison system as cruel and unusual punishment by the district court have either been affirmed by the Court of Appeals or never challenged.
The Supreme Court found the conditions in the Arkansas penal system constituted cruel and unusual punishment. The ruling was one of the first successful Supreme Court prisoner lawsuits challenging conditions of confinement. When Kaplan and Holt returned to Little Rock from Washington, then Attorney General William Jefferson Clinton hailed the landmark decision.
It wasn't until Bill Clinton became the Attorney General that there was a significant effort on the part of the state to step in and say, this is enough. We don't need to be litigating over things that we shouldn't be litigating about. And he had two members of his staff who were assigned to change things irrevocably. Then by the time he became governor, that was well institutionalized. He did a significant number of things that for the good, and he had a deep commitment to making certain that the state operated constitutionally. I mean, he deserves great credit for that. I mean, it's something that I don't know that he, looking back on everything that he has achieved, would consider that to be one of the high points of his public service and career, but I would.
The young attorneys were empowered by a vision that was laid out by Chief Justice Earl Warren in 1958 in Troy versus Dulles. The notion of cruel and unusual punishment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. Justice is considered by philosophers to have primacy over all other moral beliefs. It has a unique function. Justice polices the order between might and right. In the film Bonfire of the Vanities, Judge Leonard White says,
I'll tell you what justice is. Justice is the law. And the law is man's feeble attempt to set down the principles of decency. Decency. And decency is not a deal. It isn't an angle or a contract or a hustle. Decency is what your grandmother taught you. It's in your bones. Now you go home. Go home and be decent people. Be decent.
let's consider the implications of this struggle for justice and the notion of evolving standards of decency for our contemporary crisis in American prisons on foreign soil. On September 17, 2001, George Bush signed a secret presidential directive authorizing the CIA to create paramilitary teams to hunt, capture, detain, or kill designated terrorists almost anywhere in the world. The directive created a hidden global internment network intended for secret detention and interrogation. 2 weeks later, the president issued a secret presidential military order that purported to give him the power to detain non-citizens suspected of connection to terrorists or terrorism as enemy combatants. Such persons could be held indefinitely without charges, without a court hearing or civilian legal counsel. tried before a military tribunal where hearsay evidence would be permissible, where a majority was adequate for a guilty verdict, where sentences would include life in prison and death, and no appeals were permitted in U.S. courts.
The incarceration without a right to a hearing, without some sort of adjudication, goes contrary to me to our system of justice. We in this state, you've got to bring somebody to trial within a certain period of time, or we would automatically throw the charges out. And times we'd have some prosecutors play with an extension of time, which wasn't legitimate, and it would be appealed up to the Supreme Court. We'd say, you didn't go to trial within the designated period of time. You can't resurrect the trial. And even though a person technically that was involved in a crime would be released. But we need to have strict rules when it comes to anyone that's incarcerated. Right to hearing, right to trial, and right to be treated as a human being. Even some of them that don't act too human at times.
Well, there's obviously a tradition that dates back to John Adams of giving legal representation to clients who may be decidedly unpopular. John Adams represented the Redcoats who were associated with the Boston Massacre. And that was considered something that was a risk for him in his business as a lawyer. And it's something we look upon as in the finest tradition of American law. When you transpose that issue or that scenario onto the Guantanamo situation, it has interesting implications. There's been a lot of criticism of the lawyers who've been associated with the habeas cases, representing Guantanamo detainees. It's not exactly like the situation presented by the Boston Massacre defendants. For one, not many of these individuals are being prosecuted. Many of them are being held, and what they're trying to do by accessing the courts is very different from what the Boston Massacre soldiers were doing by seeking defense in a criminal trial. There was no question that they were entitled, the Boston Massacre soldiers were entitled to a defense. There was a substantial question as to whether the Guantanamo detainees had any right to bring legal actions to challenge the fact of their military detention, separate from the ones who were being prosecuted. So that's led to a lot of spirited debate. The fact of the matter is that a lot of attorneys in the United States have volunteered a lot of time to pressing this issue for a variety of reasons. By and large, I think your typical Guantanamo habeas attorney is motivated by a sense that, at least at the time they got involved, I would think, that the government's positions could and should be challenged legally, that the government's actions weren't within the bounds of the law. These are obviously sharply disputed opinions, but they were getting involved in an effort to vindicate their best conception of the law, which, stated in that way, is an admirable thing.
These early secret directives and policies since 9/11 led to massive sweeps that filled facilities from Guantanamo Bay to Abu Ghraib to secret prisons, with tens of thousands of prisoners suspected of supporting terrorism, individuals who could be held indefinitely without the protections of the Geneva Conventions. Bounties of anywhere from several hundred to thousands of dollars were offered by U.S. Special Forces in Afghanistan for any al-Qaeda or Taliban member. These incentives led to the imprisonment of hundreds of Afghan farmers, taxi drivers, drug addicts, shepherds, homeless, and low-level Taliban who offered nothing whatever in the form of intelligence, but many of whom nonetheless ended up imprisoned, often for years. After the Justice Department advised that Guantanamo Bay could be considered outside U.S. legal jurisdiction and thus safe from outside interference from civilian judges and defense lawyers, prisoners captured in Afghanistan were moved there beginning in early 2002. U.S. Army Colonel Lawrence Wilkerson, Chief of Staff to Secretary of State Colin Powell, confirmed that because of the utter incompetence of the battlefield vetting in Afghanistan and the incredible pressure coming down from Secretary of Defense Rumsfeld and others to just get the bastards to the interrogators, most of those detained were innocent of any substantial wrongdoing and had little intelligence value and should have been immediately released. When the government in 2006 finally prepared summaries of evidence for 517 Guantanamo detainees to justify its enemy combatant designation, only 8% were definitely identified as Al-Qaeda fighters. 66% had no definitive connection to Al-Qaeda at all. The panicked rush to round up prisoners was replicated in Iraq during the first months of the insurgency in the summer and fall of 2003. The televised images of orange-suited, shackled, and hooded prisoners at Guantanamo, and later naked, grotesquely contorted, and abused prisoners at Abu Ghraib, served as a kind of lurid recruitment poster for Al-Qaeda that visually suggested an evil, repressive, imperialistic United States. One begins to see a pattern. The movement from Secretary of Defense Rumsfeld's call to just get the bastards to the interrogators to the overflow of prisoners from Abu Ghraib to Guantanamo, rendering unworkable the very system that the Get Tough directives were meant to snap into action. Abuse was inevitable.
The Department of Defense is in the business of war and not of prisons. And so this is an unusual operation on this scale. And so when you have hundreds of men being detained by military officials, people who are used to being at war and who think with a war mindset, then you have a very different type and style of prison as well. And so the conditions are in some ways much more onerous on detainees, much more draconian, some would say, than necessary. And having set a pattern into place over several years, it's very hard to change that pattern now. And so even if courts are saying these are not the worst of the worst guys, some of these guys that you have in there are, people who have been taken by mistaken identity. Even if that's true, you have a mentality, on the other hand, of the military officials saying, no, we made a decision long ago that these guys are the worst of the worst. And so they're functioning with that paradigm.
Fear and the belief that nothing should stand in the way of protecting the country, especially not overly legalistic notions about international treaties and limitations on presidential power, drove policy. And our country is still struggling to cope with the results. For 5 years, Red Cross officials were unable to get access to the CIA's prisoners, although Geneva Conventions call for it. Finally, in 2006, Red Cross officials were allowed to interview 14 of the high-value detainees after they had been transferred to Guantanamo. The International Red Cross report described the detention and interrogation methods as tantamount to torture, and declared that American officials responsible for the abusive treatment could have committed serious crimes, grave breaches of the Geneva Conventions, and the U.S. Convention Against Torture passed by Congress in 1994. The CIA's interrogation program has been described by an insider as intentional and systematic infliction of great suffering masquerading as a legal process.
What's most disturbing is that it seems like it was a systematic package of treatment that was approved from on high and deliberately implemented in order to purportedly get people to cooperate with interrogations and give more information.
In 2001, Vice President Dick Cheney, in an interview on Meet the Press, said the government might have to go to the dark side in handling terrorist suspects. A former CIA officer recently said about the interrogations, "When you cross over that line of darkness, it's hard to come back. You lose your soul. You can do your best to justify it, but it's well outside the norm. You can't go to that dark a place without it changing you. You're inflicting something really evil and horrible on somebody." As the front page article in the New York Times August of 2009 said, the intelligence community's embrace of dark of night, snatch and grabs, secret prisons, torture, and abductions has stained the CIA's reputation and led to legal challenges, investigations, and internal divisions that may take years to resolve. On September 6 of 2006, a couple of hours before President Bush told the nation about the CIA's special program where enhanced interrogation procedures were used, across the Potomac at the Defense Department, high-ranking officers and officials introduced the new Army Field Manual for interrogators. The general declared that the military was forbidding precisely those procedures that the president had endorsed. In June 2008, the Supreme Court in Boumediene v. Bush declared that the U.S. had sovereignty over the base at Guantanamo, and thus constitutional protections do apply to prisoners there. In the majority ruling, Justice Kennedy wrote that to hold that the political branches may switch the Constitution on or off at will would lead to a regime in which they, not the Supreme Court, say what the law is. On January 22, 2009, newly elected President Obama issued a series of executive orders that placed terror suspects under the protection of the Geneva Conventions, which outlaw any cruel, inhuman, and degrading treatment. As President Obama signed the executive orders, 16 retired generals and flag officers, a phalanx of square-jawed, certified patriots, stood behind him. They said that ending coercive interrogation and detention was right for America and right for the world. 2 of the officers had sons serving in Iraq and Afghanistan. One of them, retired Major General Paul Eaton, stressed that torture is the tool of the lazy, the stupid, and the pseudo-tough. It's also perhaps the greatest recruiting tool that the terrorists have.
And the gains have been non-existent, practically, in terms of valuable intelligence information. I have no doubt that if there were more valuable intelligence that had been gathered, our government would be touting that. And we haven't heard about the benefits of torture. And what we've heard instead are, and what we know is this, that torture demeans the most foundational principles of our democracy, and that torture makes us, in some ways, lose our moral high ground, which is something that as Americans and as a democracy, we feel very strongly about. If it can happen in Arkansas, if it can happen in Texas, and if it can happen for decades and decades, even after these kinds of lawsuits are brought, then you know it can happen someplace as isolated as Guantanamo.
I think you can use, both the U.S. system to bring the detainees at Guantanamo into their rights, and I think that we can also use the recognition, the administration of what happened in Abu Ghraib as a human rights violation to raise up the rule of law and the standards in U.S. prisons as well.
The challenges of a democracy are numerous, even in the best of times. But the real test of a democracy comes when times are tough. It's then that we must remind ourselves that we are the city on a hill, the beacon of light to the rest of the world. Of those to whom so much has been given, much is still required.
Let it shine on me, let it shine on me, let your light from the lighthouse shine on me, let it shine on me, let it shine on me, let your light from the lighthouse shine on me. Now when the Methodists give out a hymn, they just keep right on, just like this thing. Amazing grace, how sweet it sounds, that saves a wretch like me. I once was lost, but now I'm found, was blind, but now I see. Let it shine on me, let it shine on me, let your light from the lighthouse shine on me, let it shine on me, let it shine on me, let your light from the lighthouse shine on me. Now here comes the Holy Ghost. The Holy Ghost come along late. And when they come along late, they get your name straight because they drive the song. Don't fool yourself. Now you're gonna pick up the speed, and that's where you get this rhythm and swing at. Let it shine on me, let it shine on me. Let your light from the lighthouse shine on me, let it shine.